back. Let's do this. You know how it goes down. Based on the facts and the facts only. So we're going to talk about this document right here. Basically, presented by the labor relations specialist. Right? And the key things, you got to hold them accountable, all right, to their actions. All right? Now you got to look at it. The key things is the date. All right? Now, all of these actions are after the individual or the officer filed the complaint with the facility's EEO. All right? The complaint would be a whistleblower's. All right? So that must take precedence first. All right? So when they knew that the dirty director was in the wrong, they came up with this, which was the fraudulent time of attendance, which the dirty director filed. Look at the date. It says 1/3/09. Remember, he did his action in 08, right? And what was that, July and August of 08? And he continued on. So to clean up his mess, because charges being brought against him, he brought about this. All right? Time of attendance that he caused. So remember, right there what it says, boom, a contract entered in void is fraud. Straight up, it's fraud. So you can put this on the table, and you can say, oh, you waive your rights, yeah, without prejudice, right there under UCC 1-308, right? You don't want to follow it? Not a problem. Follow your contract and your action of office, right? Yeah, okay then. So, because you are working for the employer, right? So that would be working for the employer. That would be subsection 2025. And yeah, that falls under you because you're in the public, even though that penal law codes and all of that is only used in the public by government officials. So if you're trying to bring this against another governmental employee, it could go right back against you. Yeah. All right. And the key thing is, what is it? Breach of official duties. All right. You as an administrator, you owe a duty as a trustee to follow due process. But what you're doing here is a criminal act. Not a problem. Not a problem. Why? Because of the simple fact that you breach due process under fundamental fairness and fundamental rights. Under fundamental rights, if you breach any part of due process, the substantive right kicks in. Under the God-given right, which is your inalienable rights or unalienable rights, that kicks in. Because the make-believe stuff under due process, man-made stuff, you breached it. So you breached it. So everything goes to the trash. Everything's automatically vetoed. Right? So you can proceed, right? And you do know, once you made this document right here, right? And you filed it on the record, right? Doesn't that fall under subsection 1116 under fraud for a city employee, which basically says that you could be removed from service. Yeah. See, because what you're doing right here is a violation of what's that? Title 18 U.S. Code 242, the privatization of a right or privilege. The right is under Civil Service Law, Section 75B. The whistleblower is under New York State Labor Law. What's that? 740. Whistleblower is under New York's local law, number 33. Whistleblower. So if the whistleblower is in place, and in order to get the whistleblower, the individual has to have two actions. The first action, he violated any law. Any law, traffic law, penal law. He did it in two, in one action. The traffic law and the penal law. Right? And then he came back and retaliated with time and attendance. The retaliation was time and attendance. He brought up the fraudulent charges. So right there, everything is scratched. That kicks in the whistleblower totally. You can play dumb all you want. Everything is scratched right from there. You could go to 40 rector and do the kangaroo court and the whole 9 yards. The judge, even the judge, oh, I'm sustaining. How are you going to sustain fraud? That would be an impropriety. Under your canons, what is that, 1-102? You're supposed to avoid impropriety, even the appearance of impropriety. This right here is an impropriety. Even though the union representation didn't advise you of your rights. This is what you write without prejudice. Because the union people are usually working with the employer. Okay? They're working with the employer. So they're working against you. They're not working for you. Yeah, not with you, for you. Because they took the act as a trustee. Representation. So they're a trustee. They're supposed to be, you're the beneficiary of the trust, and they're supposed to be acting in the best interest of the trust. All right? Because you are the beneficiary. Know your position. Even the facilities, what's that? Labor Relations Officer, right? She's a trustee. She's supposed to be operating in the public in the best interest of the trust. But she took and say, "Oh, well, we're gonna run this game. Not a problem. This is a document, right? Yeah, you signed it, right? Which makes it a contract." And once again, a contract and void is fraud. Hold them by their contract. You made up the fraudulent contract, hold you accountable to that contract. You submitted the contract on the record. What's that? Submitting an instrument on the record with false written statement. Wouldn't that be subsection 175.30? If you did it more than once, one section, because that'll be a class A misdemeanor. If you did it more than once, that makes it a felony. Yeah, that makes it a felony. I could go all day with this, with each one of your documents. You want to play the game? I'll play the game with you and hold your documents out there in the public sector. Hold you accountable. All right? Like I said, press pause, read it, all right? And make sure you do your research on this. And remember, you got to use what they used against you back against them and hold them accountable under their oath. Remember, they work for the city. In order to work for New York City, right up there, New York City, you have to take an oath of office. And you're supposed to be truthful and faithful. So, using this right here, explain how you was truthful and faithful. When there was an EEO complaint in process, the EEO didn't complete her alleged investigation until, what was that, October 2009? And you holding this in March 2009? That's a breach right there, baby. That's a breach right there. On that note, I'm out. Later.